rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Welcome to the Arizona Court of Appeals, Division 1. This is cause number CACV 130051, A Plan et al. Versus Quarles and Brady. For your information, these proceedings are being recorded, and hopefully in a couple of weeks, you might, if everything works, you'll be able to see yourselves on YouTube. Here, I guess it's 40 minutes of fame, 20 each. So as you approach the podium, please say your name and who you are representing. Each side will have 20 minutes. The podium on the clock on the clock on the podium will tell you how much time you have left. Appellant, you may reserve a portion of your time for rebuttal. If you'll tell us how much time you would like to reserve, we will try not to horn in on your time. We have read the briefs and conferenced the case this morning, so we're familiar with the facts and the legal arguments. We've looked at relevant portions of the record. So with that, you may begin.
Good morning, Your Honors. I'm Ethan Steele, attorney for the appellants. Thank you for hearing the appellant's case this morning. So for ease of identification, I will be calling the appellants the plaintiffs or perhaps the pilots. They are the retired TWA pilots. The defendant would be the Quarles-Brady firm. I'll call them Quarles-Brady. And there were two legal cases in the underlying facts. There was first the ongoing ALPA case, ALPA. And that was the case that the plaintiffs hired Quarles and Brady to intervene into. And when there was a failure to timely intervene, upon the suggestion of the Quarles-Brady firm, a new case, the Adams case, was filed. And so I will be referring to those. And basically the plaintiffs had the understanding that the Adams case would accomplish the same goals as the ALPA case. And it was after the ALPA case was affirmed on appeal that the plaintiffs discharged Quarles and Brady and hired a new attorney and proceeded to the end of the Adams case. And then at the end of the Adams case was when this malpractice case was brought, focused on the failure to intervene in the ALPA case. So the trial court granted summary judgment based on the statute of limitations, and our position is that that was error, at least for two reasons, or two categories of reasons. One, the trial court incorrectly found that plaintiffs' damages were irremediable and irrevocable before the conclusion of the Adams case. And two, the trial court failed to consider whether Quarles and Brady was stopped from asserting the statute of limitations due to the evidence that they induced the plaintiff's reliance upon the until the conclusion of the Adams case. So the first point that I'll discuss is that plaintiffs' damages were not irrevocable and irremediable until the Adams case was concluded. Okay, for that test, you have to show that that negligence occurred, and also that the damages were irremediable. And it's a good tongue twister word, but the idea is you can't remedy them any longer. And I have three general reasons why the court's finding that the case was irremediable before Adams was concluded. The first, the two cases, the Adams case sought to accomplish the same goals as the ALPA case. Quarles and Brady expressly represented to the plaintiffs that following the Adams would remedy the failure to intervene in the earlier ALPA case, and the plaintiffs acted upon it, and that was expressed. And in fact, this express representation, the mitigation, was in that partial transcript of the fundraising video that we had transcribed and that I attached as one of the two exhibits to the brief. Yes, sir.
Yes, counsel, you're not really suggesting that Quarles and Brady guaranteed that the Adams litigation would result in victory for the pilots?
No, not at all guaranteed. No, so because it's more whether the question is whether the pilots were entitled to wait until the conclusion of Adams before saying, hey, it's your fault we didn't intervene in time, and that prejudiced the outcome in ALPA and or in Adams. And so one of the issues that I was going to address later is the question that, there was no claim anyway, you wouldn't have one anyway. That's a question of fact. We see that the failure to intervene in ALPA was brought up several important times in the subsequent Adams litigation, and that the ultimate decision by the Court of Appeals affirming the decision throwing out the Adams case basically gave a one-line explanation following the precedent in ALPA. And until the ALPA case was decided, that was unsettled law. And we have an expert saying that his belief that had there been an intervention in the ALPA case when it was at trial, before the ALPA decision got an appellate ruling, that they could have had a different outcome. So,
going back to the argument you were starting to make about that your remedial damages, how would you characterize your client's letter to Quarles and Brady in
Yes.
October of 2003 in terms of fact
I-
and legal significance?
okay, I anticipated that subject would come
Oh,
up. The
might,
trial
yeah.
court obviously gave it the primary significance. Okay, the letter doesn't claim that the plaintiffs were irrevocably damaged. It really said, we may suffer prejudice in the outcome of the Adams case as a result of the failure to intervene.
But didn't the letter, I mean, maybe I'm misremembering it, but didn't it say we've been damaged because we couldn't intervene? That's number one. And secondly, we've incurred additional attorney's fees.
By the way, those additional attorney's fees are in the Adams case, and I will get to the idea of splitting the Adams case. You weren't entitled to wait till the Adams because it's a separate case from the earlier ALPA case. And if those fees are incurred in the Adams case, then those are damages, the wasted fees in the Adams case, those are damages that, by definition, await the outcome of the Adams case. So we can't split the ALPA case and the Adams case, split them up in terms of causality, yet not split them up in terms of damages.
Well, go ahead, I'm sorry.
Yes, so there was a course of conduct. It was the failure to intervene, but then following in a way and really intimately connected to the failure to intervene was the proposal, don't worry, we can go ahead and file the new Adams case and we'll accomplish the same result. That was a negligent act also, and that caused the damages of the wasting of the fees in the Adams case. And so that's a separate, if you're going to separate those two cases in terms of causality, then you have to separate them in terms of damages. Our position is that the two cases, in fact, are not separated in terms of causality, that they are so intimately intertwined, coming from the same set of facts, and the Quarles and Brady firm's participation in the second case. It was the same legal matter as far as the frame of mind of the plaintiffs, and I would say the Quarles and Brady's firm. So I think it's putting form over substance to say it was two separate cases. But if you are going to say they're two separate cases, then if they're separate for causality, then they're separate for damages. So by trying to, in effect, make up for the negligence of failing to intervene in time by encouraging them and the plaintiffs are saying, we can do the Adams case, don't worry, then that was an act of negligence which gave rise to those attorney's fees. So the wasted fees in the Adams case. And
But there is no doubt that on October 15th of 2003, your client said, we have suffered a specific injury as a result, Quarles and Brady, of your failure to do a specific thing.
the specific injury was the failure to intervene. But but that doesn't make it by definition two separate cases.
And I'm not going there.
Okay.
I just want to know that as of the October 15th, 2003 correspondence,
Yes.
your clients asserted that they had specifically been injured as a result of Quarles and Brady's failure to do a specific.
Yes, they identified the failure to intervene as an act of negligence. Now, that's only the first part of the two-part test. The other part of the test is, okay, were those damages at that point irremediable? And our position is, for one, they were not irremediable, that the Adams case could have solved them, and it's a fallacy to call them two separate cases. Our position number two is Quarles and Brady represented that the Adams case was a way to remedy the failure to intervene, so they're kind of stopped from taking a different position now. And position number three is just because that letter identified the negligence, doesn't answer the question of, well, then did the plaintiffs bring their suit in time? When we look at the Nolde case, which maps out in detail, the elements for equitable estoppel against statute of limitations due to inducing forbearance. That's kind of the concepts in the Nolde case. When we look at that, the fourth element, and I'm happy to go through all the elements, but I did map them out in my reply brief in good detail, I thought. The fourth element is, okay, after the circumstances that gave rise to the inducement, did you bring your case in time? Remember, in Nolde, it was a coach who molested some high school students, and they did not bring their claims till they were several years into adulthood. And the idea was, okay, the wrong occurred, the negligent or the wrongful act occurred. The irremediability of its harm is self-evident right there. Nothing you can do to undo the molestation. Yet there was also the question is, okay, how long did they wait before bringing their claims? Was that reasonable? So that's the fourth element in Nolde. Applying that test to our circumstance, yes, the negligence of failing to intervene occurred, but the second part is, or under Nolde, the question is, there's no question that the plaintiffs were induced to rely upon Adams by initiating Adams at Quarles and Brady's suggestion. So the question is then, was it reasonable for the plaintiffs to wait until the conclusion of Adams? At the very least, that's a question of fact. But the fact that the plaintiff's letter identified you were negligent is not the same as saying, and we now conclude, therefore, that our damages are irremediable. No, it's not so. That's not what was represented to them. That's not what they believed. That's not what they acted upon. They still believe that, well, we might as well see this Adams case through to conclusion because we still might win it and we might get the relief we sought, which is preservation of our pensions. So that question still, in spite of the point yes, Your Honor, they did recognize negligence had occurred. Damage, we were damaged by not intervening, but it's not defining specific damage, and there's still the important idea that they believed it was still remediable damage, that it could be cured or fixed, and that belief was induced in them by the Quarles and Brady's conduct. So the question is, was it reasonable for them to wait to the end of Adams? We say yes, or at the very least, that's a question for the jury under the Nolde case.
Well, let's talk about the end of Adams, though. I mean, on August 25th of 2004, the federal district court ruled against you, correct?
That is correct. And then it went through the appellate process, Your Honor.
So is the end of the process always going to be, is the rule that the statute of limitations on a malpractice claim doesn't begin to run until the United States Supreme Court denies cert?
It depends on the circumstance. I would say, we have there's that Kinnicott v. Olcott case. I'm not sure I'm pronouncing it. It starts with a K in versus Olcott case, where the attorney deficiently drafted a deed, and then one of the parties got the deed. They got in a fight with the two people's interested in the deed, and while they were fighting, the attorney drafted deed was not involved in that litigation and did not represent the party in that litigation. And that ruling said, well, at a certain point, I believe when you had summary judgment against you, you should have realized you were damaged by the deed. But they're pursuing, that's a different situation. That wasn't, the lawsuit was not initiated by the same attorney who drafted the deed there, and there's no indication that he was given that heads up. This is a very different situation where the law firm that committed the negligence played the role in inducing the process that sought to remedy that negligence.
So in your mind, the subsequent events where Quarles and Brady is discharged, there is new counsel that comes in that advises the client whether to proceed with the litigation or not. That's simply an additional fact that you roll into something that's presented to a trier of fact?
Yes, Your Honor, about whether they acted reasonable under the circumstances. I mean, we would say, well, that the attorney not only did the conduct suggested by Quarles and Brady infect the client's frame of mind, but even when they asked the other attorney, is this the right way to go, that attorney said yes. So he also believed the idea that that was originally the idea that was created by Quarles and Brady, that the Adams case could remedy the failure to intervene. So why weren't they entitled to see it through to the end? And the fact that the other attorney agreed with that representation that Quarles and Brady originally made, I think that supports the idea that the plaintiffs were reasonable in waiting until the end of the Adams case. they knew this case was ongoing. They were not entitled to repose we didn't know this was happening at all kind of. That's not true at all. So when they played a role in initiating that, and so it's a matter of was this one case or two. But let me say something. I think I did. I raised that point, but I have other ones. What's my time here?
6 minutes.
6 minutes left. I'm going to end around 5, but let's just make sure here. Okay, so I raised the estoppel. It was remediable. We said it's not two cases, it's one case. We raised the estoppel as clearly a question of fact on estoppel. All those elements in nullity are met. I'm sorry, then the stuff about, you have to show this hyper-technical reading, I think I rebutted that very effectively in the reply brief, that when we look at nullity, it was a little bit focused on certain situation there, but duress, the plaintiffs worrying about their pensions, that's acting under duress by putting all that money and believing in the Adams case. I've responded on the letter. But for causation, they say applies to the wasted fees claim. Come on. That's not the only way to, there's other ways of showing proximate causation of wasted fees. Otherwise, they're saying, yes, you paid me for something to do something, and yes, I didn't do it, but I don't have to pay you back because you wouldn't have won anyway. That doesn't fly. And then that's just common sense. So applying, but for causation to the wasted fees claim, no, I'm sorry. But let's hear if he can explain that. You must defer to the trial court's findings on the summary judgment as an equitable decision. No, that's wrong. First of all, you have just as good access to the evidence as the trial court does on summary judgment, and based on nullity, it's a finding for the trier of fact. The court it's an interesting philosophical discussion about where the courts have equity powers or not. I would say it's in fashioning a remedy, but here, where all the elements that would contribute to a forbearance and estoppel based on forbearance, where those are mapped out and have been identified in nullity and stated as a fact question for the jury, that's what it should be. So it's important that we apply the correct standard of proof on the question of the estoppel claim in this case. We discussed whether intervening in time could have changed the legal position, and our position is it could, and we had an expert who said so.
Could that motion to intervene have been filed before your clients had signed their fee agreements and authorized Quarles and Brady to proceed?
Yes, of course. It could have been filed earlier. So but that's what the Quarles and Brady firm, the Quarles and Brady firm met and basically said, according to the plaintiffs, said a motion to intervene is a simple thing. It can be done. We can have it done in 2 to 3 weeks for $15,000 to $20,000. And 3 months later, it wasn't done because what happened was they got all preoccupied. We need the broadest class possible to cover all possible permutations. That may be true. That eventually, to pursue a class action, you do have to get all those things lined up. But when the clock is ticking, the parties knew there was an outstanding motion for summary judgment that had been pending 6 months. When the clock is ticking and everybody recognized the urgency and Quarles and Brady committed to doing it in 2 to 3 weeks for $15,000 to $20,000, then our expert said you can file a class action with one plaintiff, and then you can amend your class to add the other plaintiffs in. That's a totally acceptable way to do it, and that's what should have been done in that urgent situation. And so, and I cited case law that supports that very thing. So I don't think there's any question about that. There was no excuse for the 3-month delay, except that, I can get into why it happened. They were trying to line up the class just right to maximize their fees. So, that's all well and good, but get the thing into the court. And the loss of, yes?
You've got about 2.5 minutes.
Okay.
I don't know if you want to
Yeah,
reserve
thank
the
you.
rest of your time.
And the last thing is just the loss of a chance. That we did raise preponderance of the evidence supported by an expert in this opposition to summary judgment. Yes, it wasn't formally in the pleadings, but we could amend those pleadings to conform to that evidence. And loss of a chance does apply also in this situation because they were being rescued from an impending outcome. All right, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Thomas Hudson on behalf of the defendant appellee, Quarles and Brady, and with me at counsel table today is my partner, Jeff Sturr. Your Honors, it is the very nature of litigation that in any given case, there is a winner and a loser. And we know that in most cases, indeed, virtually all cases, that is not the product of any malpractice. This is such a case. And indeed, we would submit that the malpractice claim, as alleged in this case, on the merits, suffers from a fundamental legal flaw. But before getting to that, let me begin by addressing the statute of limitations. On that issue, it is undisputed that the plaintiffs knew they had been harmed in October 2003. It's an undisputed fact in the statement of facts in the summary judgment, and it's demonstrated by their own documents and their own admissions. And Judge Winthrop, you noted the October 2003 document. If the court hasn't looked at it, look also at Exhibit I on page 138 of the deposition, where one of the plaintiffs testifies about the letter. Was it your view that as a result of Quarles and Brady's failure to file the motion to intervene, that you and the other named plaintiffs have been harmed? Absolutely. And that was the view of Mr. McHugh and others. I think that was the view of everybody on the board and all the named plaintiffs. As of this date, yes. And of course, it was undisputed in the statement of facts. So we're done on that. On top of that, it is also undisputed that in 2004, the plaintiffs are then consulting with another law firm about whether to sue Quarles and Brady for malpractice. So given that it's undisputed that they believe they've been harmed, undisputed that they're consulting with other counsel, Judge Cooper correctly applied the statute of limitations in this case. And then we have sort of this issue about irremediable harm, and Judge Winthrop, if you have a question, I welcome it.
Oh, I was just, I presume since nobody talked about it, does this record reflect whether there was ever a tolling agreement proposed to Quarles and Brady?
It does not. And that would have been a simple thing to do when they're consulting with other attorneys at that time, to have made a request and either get one or not. And of course, that would have put everyone on notice. But no, there's nothing in the record to suggest that that was done. And so let me address briefly this argument about, well, we could pursue the second action and see what happened before we had to file any lawsuit. And there's two fundamental problems with this argument. First, it ignores the rule in Arizona that a claim for malpractice accrues when the client has suffered some damage. The case law couldn't be more clear. It explicitly says that the client need not sustain all of the damage or even the greater part of the damage. And second, the argument confuses the occurrence of harm with the concept of mitigation. Once the Quarles and Brady had failed to intervene in the first action, the damages from that malpractice had occurred. They were complete. Now, what they're arguing, what they're saying in essence is, well, we could have done other things to reduce or eliminate the damage. We could have filed another lawsuit. Perhaps other things could have been done as well. But the fact that a party can mitigate its damages through subsequent litigation or other means is not any basis at all to toll the statute of limitations.
What if Quarles and Brady had continued as counsel through the completion of the Adams litigation instead of being discharged in 2003 or 4, whenever it was? What if they continued to the conclusion? Would the statute have been tolled until that litigation in which they actively represented the clients continued?
If that had happened, Judge Winthrop, we would then have to confront the continuous representation rule. And certainly there's an argument to be made that under those circumstances, this would be a harder case. I think the answer would still be no, but that would be a much more difficult case. And certainly if I'm writing the decision in this case, I note that that's not being decided in this case. And as I noted, I mean, what's striking here is they fired Quarles and Brady, hired new lawyers, and consulted with them about whether to sue Quarles and Brady.
If your answer is no, then the October 15th, 2003 start date would have triggered the necessity of Quarles and Brady leaving the representation, wouldn't it? Because they couldn't have maintained a malpractice action against them at the same time Quarles and Brady was representing them in the Adams case?
Yeah, I think the answer to that is also no, Judge Jones, but it really goes to the merits of the underlying legal malpractice claim, which, as I say, and I'm happy to talk about it any time, but I don't want to cut short the discussion on the statute of limitations issue. And the reason it's no is because the claim is it's a loser. The underlying malpractice claim, and maybe we should talk about that. But so let me just wrap up on the statute of limitations again. If there's more questions, and I recognize Judge Winthrop, and I agree, much harder case if you're confronting the continuous representation rule. That's not an issue in this case. And what we would say simply is mitigation, the possibility, it may be true in a wide variety of circumstances that you could file a second lawsuit to reduce or eliminate the damages. Sometimes there's multiple parties that can be added as a subsequent time. And that's really, when you look at it, that's the argument that's being made. So unless there are more questions on the statute of limitations, and I don't intend to discuss estoppel. I think for the same reasons the claim accrued, the fact that they're consulting other counsel is decisive on the second element of the nullity test. So I don't intend to spend any time on that unless the court has questions. But let's talk a little bit about the underlying malpractice claim, because it confirms without a doubt that the court should affirm. The basic theory, right, that's being advocated is that Quarles and Brady's failure to timely intervene, and assuming, of course, that motion gets granted, Quarles and Brady then should have been made what we've been calling the 270-day argument. And that argument, in sum, is that without ERISA provision 4004, which had been repealed, the Pension Benefit Guarantee Fund lacked the authority to compromise liability under 4062. Now, it's a little technical, but bear with me because I think it's illuminating. So they're saying that's the argument that should be made. Now, it's worth noting at the outset, Quarles and Brady had no plans to make that so-called 270-day argument. And we know that no other lawyer involved in the first action actually made that argument. So the implication of the underlying malpractice theory that's being alleged here is not only did Quarles and Brady commit malpractice, but so did every other lawyer involved in that case. So that's one explanation. The better explanation for why nobody made that argument is because it is a loser. Decisively, we know that, in fact, they ultimately had the opportunity to make that argument. It was presented to the D.C. District Court. It was considered by the D.C. District Court, and that argument was rejected. We also know, as best we can tell, no court anywhere has ever accepted that argument, and as best we can tell, no lawyers other than the counsel that replaced Quarles and Brady has ever even advanced that argument after Congress amended ERISA in 86 and 87. So, and that is the fundamental problem, is that Congress made amendments that gave the Pension Benefit Guarantee Corporation authority to do exactly what it did. And that, and I encourage you, if you have any questions, it's briefed thoroughly and in a very clear manner in the briefing that's included in our appendix beginning at page 157. Okay, so this is, and what's striking now as we look back on this case, we've had all the briefing, we've had the argument, and we've had the decisions that have construed sections 4067 and 4062 as giving the PBGC the authority it did. And there's never been any explanation as to why those courts misconstrued those provisions. We haven't, it's nowhere in the briefing to be found. Nor is there any explanation as to why the Pension Benefit Guarantee Corporation's interpretation of those provisions should not be entitled to deference. And as we know from the record, it's a congressional created entity. It's reporting to Congress. It reported this settlement agreement to Congress, and it has the authority to interpret these provisions. So my point is, the argument would not have made any difference. It's a loser, and it's a question of law. The Mulliver case, the Roush versus Mulliver case, makes that crystal clear. When the underlying issue would have been decided by a court, it's a legal issue in this case. It's ultimately a question of law for this court. That argument would have made no difference. And because the argument would have made no difference, there can't be any malpractice claim. Now, Judge Jones correctly granted the summary judgment on the statute of limitations, but I wanted to emphasize that as well because I think it makes crystal clear that there's no question this court should affirm. Unless the court has further questions, we would ask the court to affirm. Thank you very much.
Briefly on reply, Your Honors, I would urge the court to consider the Glaze v. Larson case on the fact that why this should be considered as one legal matter and not as two separate cases. There's no doubt that had the plaintiffs sued Quarles and Brady while the Adams case is still pending, Quarles and Brady would have said that that case was premature and would have moved for that matter to be stayed. And that is the very purpose that in the Glaze v. Larson, where they identify the AMFAC ruling and why it's not advised to bring premature cases.
Mr. Steele, could you address Mr. Hudson's point that he made as he left the podium, which was, even though the trial court's ruling was based on the statute of limitations, there was an argument advanced below on the underlying merits of the malpractice case.
Yes,
in other
yes.
words, that this is a point of law as to whether this this argument would have failed as a matter of law.
Yes, and I understand. So to outline that briefly, first of all, what it refers to, there were really separate damage claims in this case. So there was the lost chance on the pension claims, and that is what this is. But I also want to point out that there were the claims for the wasted fees for failing to intervene in ALPA and the wasted fees in subsequently following the Adams case. But back to the first point, the lost pension claims, that's the question based on the federal law that was being addressed. And our position is that, yes, Quarles Brady argued on behalf, they said, no explanation for why the courts didn't address this issue, the 270-day argument. And the explanation is because once it was decided in ALPA case about what the Pension Benefit Guarantee Corporation was entitled to do, that became precedent. And so then it's a matter of stare decisis that the courts are very disinclined to overturn that precedent. And it's shown by the fact that the failure to intervene was brought up. So the question is, gee, was this solely a question of law that would have reached the same result in any case, or are there some factual issues that could have impacted the impact of the plaintiff's claims? And our position is, had they intervened, they could have offered the argument then and reached a successful result. But as a result, adverse precedent was established, and they, at that point, then they could not proceed any further. Thank you.
Thank you, counsel. We will take this matter under advisement and issue a ruling in due course. And with that, we are adjourned. Thank you.